Okay, welcome everyone to our webinar on managing IP disputes, navigating copyright design and trademark infringements. My name's Charlotte Hale and I'm a practice leader in the disputes and litigation team specialising in intellectual property disputes. Before we begin, a couple of quick housekeeping items. You'll receive a recording and slides in your email. Submit your questions in the Q&A box and we'll answer them at the end. And please complete the feedback survey after the webinar. For the next 48 hours, you are eligible for a free consultation with LegalVision to discuss how we can help your business. Provide your contact details in the survey at the end of the webinar. Okay, so today we'll be discussing copyright design and trademarks, how to identify infringement, dispute resolution options and enforcement strategies, and prevention strategies as well. So IP has really become one of the most valuable assets for businesses of all sizes, whether it's your distinctive brand or a unique piece of creative work. IP often represents the core value that really sets your organisation apart from your competitors. And in the ease of this far-reaching reproduction and distribution that the online world offers, it means that IP infringement now occurs at this unprecedented scale and speed. Businesses are facing this dual challenge of protecting their own intellectual assets while also ensuring they don't inadvertently infringe on others' rights, which is very easy to do. In this landscape, effective IP management and dispute resolution have become really critical business capabilities, which is really why it's important to understand your position in this. Whether you're a tech startup protecting software code or innovations, or a creative professional protecting your artistic works, or even an established corporation managing a really vast IP portfolio, your success really largely depends on how well you can protect and defend your IP and avoid claims of infringement against you. So let's begin by exploring the main types of IP infringement we'll focus on today. So we're going to talk about copyright, design and trademark protection. So firstly, let's talk about copyright infringement. In Australia, copyright automatically protects original creative works, including literary, dramatic, musical and artistic works, as well as film, sound recordings and so on. So works such as your website content, marketing materials, product descriptions, software code, even internal manuals and other descriptions can be protected. There's no registration system in Australia, so protection automatically applies and begins as soon as the work is created. And generally, it lasts for the creator's life plus 70 years. Infringement occurs when someone uses, reproduces, or distributes a substantial part of copyrighted material without permission. We see copyright infringement frequently in the online world, especially unauthorized use of photographs on websites, sharing of copyrighted music, sharing of newspaper articles, or just copying protected text from your website and so on without permission. So now let's move on to design, which is quite different. A design refers to the overall visual appearance of a product, including its shape, pattern, and ornamentation. Registered designs are usually used for things like furniture pieces, fashion items like handbags and clothing, or product packaging is also a common one. To be protected, designs must be new and they must be distinctive and they must be registered with IP Australia, unlike copyright, which is automatic. So registration offers protection up to 10 years, which is obviously significantly less than copyright protection. Design registration only protects a product's appearance, not its design process, any functionality, elements, any materials used, or any intangible designs like logos or concept art. Infringement occurs when a product embodies a design that is substantially similar in its overall impression to a registered design, considering the features that make that original design distinctive. Now, the third type of infringement we're discussing is trademark, which I would say is probably the most relevant and most visible form of IP infringement in the marketplace. So trademarks serve as badges of origin. They're how customers identify and distinguish your products or services from those of another. They can be logos, words, phrases, even sounds or shapes. The Trademarks Act provides protection for registered marks, renewable every 10 years, really forever, or for as long as you are consistently using that mark. Trademark infringement occurs when someone uses a sign that is substantially identical or deceptively similar to a registered trademark without the owner's permission and in relation to the same goods or services for which it's registered. There's also some protection for unregistered marks under common law through the tort of passing off and through misleading and deceptive conduct under the Australian consumer law. That said, trademark registration really does give you the greatest protection, and it's certainly something we would always recommend when you're starting off a brand and want to make sure that you're validly protecting your rights. Okay, so now let's move on to talking about identifying infringement. Identifying infringement early is really quite crucial, whether you're monitoring potential infringement of your rights and ensuring that your business isn't inadvertently infringing others' IP. It's very important. One of the most effective approaches is implementing kind of a periodic comprehensive monitoring strategy. So this means things like regularly searching online marketplaces like Amazon, eBay, Alibaba, social media, setting up Google alerts as well can be really helpful for your brand names and for select products. Keeping a close eye on trademark or design registers as well is very important. And just generally, we would always suggest keeping an eye on your biggest competitors in the market, because, I mean, really, if they are infringing on your IP, that's what's going to cause you the most significant damage. So now let's talk about potential warning signs. You should always pay attention to any warning signs in the market and be really across your, the commercial actions of your business. So are similar products suddenly appearing in the market? Customers suddenly experiencing and expressing confusion about where your products come from? Like, are you receiving bad reviews from consumers or complaints from consumers about products that aren't sold by you or just seem a little bit off? Have you noticed an unexpected decrease in sales? That's obviously a big one. So when you suspect infringement, the first step should be to gather all evidence, including dated screenshots, any product samples, any customer complaints, like I said, or any other kind of evidence of confusion, people commenting on the wrong social media page, anything of that kind of vein. You should assess any financial impact on your brand. So, for example, looking at evidence of decreased or lost sales. You should also consider making test purchases, so to purchase any counterfeit or suspicious goods, so that we can really confirm the infringement and see how problematic it is. After you have collected evidence, we would suggest then consulting with an IP specialist to really assess your position and develop a more bespoke strategy for enforcement going forward. Similarly, if you receive a claim that you're infringing someone else's IP, document everything and seek immediate legal advice to understand your position and how best to respond. So now let's talk about what to do if there is some kind of infringement. So often the first formal step is to send a cease and desist letter. These letters carefully set out your rights in the IP, providing any necessary proof, detail the alleged infringement, including any evidence like screenshots or so on, set out why this breaches the law, so referring to particular acts and proving that. And most importantly, they make specific demands. These demands are usually in the form of undertakings, which are legally enforceable promises not to take further action or to stop the infringement or so on. And the way that this is framed is if they do these matters, you'll consider not bringing proceedings. So, I mean, sometimes this is enough to resolve the situation anyway, but let's look at what happens next. So if the letter doesn't work, you have several options. You might want to look into some kind of alternative dispute resolution methods like mediation, for instance, can be a cost-effective and confidential way of trying to resolve a matter while also maintaining business relationships as well. Unlike litigation, there won't be a binding decision made. There'll just be an objective, impartial person that tries to assist reaching an agreement between the two parties. And if there isn't one made, then you walk away. You can also engage in negotiation discussions in an attempt to resolve the matter commercially without litigation again. You may even propose an informal without prejudice or off the record chat over the telephone to see if you can reach an agreement. In both circumstances, you'll be looking at exploring a settlement agreement or a coexistence agreement, where the other side, as an example, agrees to limit their use to certain areas in jurisdictions or with products or services. They might agree to make branding changes. They might agree to pay financial compensation for any damage you've suffered. You may also explore paying another party rebranding costs in certain circumstances or allowing them like a period to phase out use of the IP. That's especially in situations where your case might not be as strong and you really want to avoid court proceedings. So before initiating federal court proceedings, which you usually go in these situations, federal court or federal circuit court, it's crucial to carefully evaluate the commercial aspects of your case. So consider whether the infringement is causing you significant financial damage, or if legal action is necessary to deter other potential infringers. So if you're seeing a lot of infringement in the marketplace, it might be really important to send a message to all of those infringers so they know you're serious. You'll need to assess your prospects of success in bringing the claim by examining the strength of your evidence and analysing the likelihood of actually recovering damages as well. So the location and nature of the infringer are also key factors. Pursuing legal action against an overseas entity, for instance, can be particularly challenging, while the size of the infringing party can also significantly impact your recovery prospects. So a large company might have the means to pay you damages, but they might also invest a lot of money in defending the matter. Whereas an individual infringer might be easier to win against, but they have nothing to recover, so you won't get damages anyway. So these factors should be carefully weighed against the substantial costs of federal court proceedings, also the time commitment that they require, and really the overall effort involved in litigation. The decision to proceed should really be based on a pragmatic assessment of whether the potential benefits outweigh the significant investment of resources that federal court action demands. If successful in court, however, and you have a great case that should go to court, several remedies are available. So the court may grant injunctions, both temporary or permanent, to stop the infringing activity. These injunctions are particularly valuable as they provide immediate relief by stopping the infringing conduct while the rest of the decisions are made by a court and the whole litigation process goes ahead. Monetary compensation through damages or an account of profits might be awarded. An account of profits is the amount of profits the other side has profited from by using your infringing material. Importantly, you might also recover a portion of your legal costs as well on top of that. Importantly, in IP infringement matters, additional damages can often be awarded in particularly egregious cases. So that's situations where, for instance, the other side has acted really poorly since being alerted to the infringement, for example, refusing to take down the material or not being, open to discussions. Or whether there's a really strong need to deter future infringement. So what's important is that these additional damages can sometimes be much larger than your actual compensatory damages. Like, for instance, in a Universal Music and Palmer, Mr. Palmer was ordered to pay $500,000 in compensatory damages, but $1 million in additional damages, which is obviously a lot. This is in order to punish or deter serious infringements. It is worth noting that these same remedies could also be awarded against you if you've infringed IP. So that's why it's really important to take action quickly. If there's a potential infringement by you, you should remove the material or discuss this with an IP lawyer before, ignoring it, for instance. Okay, so there are also specific mechanisms for particular situations. Where registered rights are concerned, you may be able to challenge the registration of a competing trademark or design through IP Australia. For trademarks, oppositions can be filed within 2 months of another trademark being advertised for registration, typically on grounds like confusing similarity with existing marks, lack of distinctiveness, or bad faith registration. For designs, interested parties can challenge a design's validity after registration through a revocation process, usually based on grounds that the design wasn't new or distinctive when filed, or that the registered owner isn't entitled to that design. These oppositions, while still costly to some extent, they're significantly cheaper than court proceedings and often a lot faster too. For domain names incorporating your trademark, you can lodge a domain name dispute. If it's a .au name, it is handled under the AU dispute resolution policy. And for any other names, .com, .org, whatever, it's handled through the Uniform Domain Name Dispute Resolution Policy. So to succeed in these claims, the complainant must prove that the domain name is identical or confusingly similar to their trademark or unregistered mark as well. The registrant has no rights or legitimate interest in the domain name, and that the domain name was registered or used in bad faith for an .au mark, or the domain name was registered and used in bad faith for a .com. So the process is handled online completely. It usually takes about 2 months, which is quite fast. It's much cheaper than court proceedings. If successful, the only relief is cancellation of the domain name or transfer to you. And bad faith examples include things like cyber squatting, so where you register a trademark to sell it on purpose to the trademark owner for an exorbitant price usually, or using domains to divert customers from competitors. So this is a really useful area if you don't know who the other side is. If they're overseas, they don't have money, it's really effective because you don't need those details to lodge the complaint. You may also wish to consider lodging a notice of objection with customs. This is a formal process where an IP owner can alert the Australian Border Force to watch for counterfeit goods. When suspected infringing goods are detected, the ABF will seize them and notify the rights holder. This is a very cost-effective way to stop infringement or counterfeits entering Australia at the outset. It's something that we can help with at LegalVision. We can also help do that in the US as well, which can be really helpful. You can also lodge takedown requests as a very initial action with online platforms through their own online complaint procedures. So platforms like Amazon, Alibaba, Facebook, Meta, Instagram have their own IP complaint system. Usually you just have to provide some kind of proof of IP rights, and they typically respond within 24 to 48 hours. And multiple complaints about the same seller can then sometimes lead to account termination, which is helpful. But that said, because it's the internet, you need to monitor regularly, as infringing listings can often reappear under different accounts. Okay, so now let's talk about prevention. Because really the best way to avoid IP disputes altogether is to avoid them. So these prevention strategies apply whether you're protecting your own IP or ensuring you don't inadvertently infringe others' IP. So you should implement comprehensive IP protection strategies. This can include things like registering trademarks and designs where appropriate, both in Australia and also overseas, if that's where you're trading. Use copyright notices on all your original works. That is that little C in the circle. While it doesn't offer any additional protection, it can be a really good tool at warning others that you're the copyright owner, and that reproducing any of your material will result in an enforcement action, because often people don't really understand that material is protected by copyright. As copyright is not a registration system in Australia, you should make sure you maintain detailed records of creation and use as well. So you can clearly show a timeline of creation and how you own it, should it be questioned. So, you know, when you draw some kind of artistic work, you might want to show like how it led to the final result, or so on. If you're selling on platforms like Amazon, as I've mentioned before, another thing to consider is US copyright registration, which is a registration system for some kind of additional protection. A lot of these online platforms and marketplaces are US based, and this can be really helpful in proving ownership. It's recognized in Australia. It means that you can just produce a certificate as opposed to showing like documents of creation. And again, this is something that we offer at LegalVision US copyright registration. So just as importantly, you should establish clear procedures to verify that any of your new products, services, or marketing materials don't infringe existing IP rights. So this might involve conducting trademark searches before launching new brands, design searches before releasing new products or packaging, and copyright clearance processes for marketing materials, images that you're planning on using, or any other products like patterns that you're using on things, and so on. So internal policies are also crucial. We would always suggest training your employees, not only about protecting your rights, but those of others again. I would suggest doing this periodically, like as an information session on IP. We've done this kind of thing for businesses in the past, which is really helpful. I would also ensure proper procedures are in place for assigning IP created by employees to a business. This is more relevant with independent contractors. The position in Australia is an independent contractor will retain their IP, even if it's created for a third party, unless it's assigned by contract. So I'd be looking especially at situations where you've employed a marketing agency or website developer who've created something for you, and make sure you have clear contracts in place assigning that IP to you. You should also establish clear guidelines for using third-party IP, as I keep saying. For example, we see a lot of infringement claims made against businesses whose employees have inadvertently used unlicensed images in their marketing materials or on social media especially. So if you employ this kind of two-way approach of protecting your assets and minimizing risk of infringement, claims against your organisation, it's really helpful. And then finally, regular IP audits are valuable tools for maintaining this balance. So I'd suggest periodic reviews of your own IP portfolio would be helpful. That will help identify gaps in your protection and ensure all registrations are current. For example, you might have gone into a different, area of goods or services and you haven't registered your trademark in those particular classes, and that might be something that you need to do. It's also a really excellent opportunity to review your use of third-party IP as well, and verify that you have all necessary licenses and permissions in place and that those are up to date. For example, we also see a lot of claims against businesses for software license infringement. So you might have employed a number of new employees and your license doesn't cover that amount of seats. And so you might need to be updating your software license, which, an infringement of software licensing can be quite expensive. So that's something to consider. Okay, so to summarize what we've spoken about, managing IP disputes does require this dual perspective, protecting your rights while respecting the rights of others. By being proactive in both protection and compliance, you can really significantly reduce the risk of costly disputes from either direction. So incorporate prevention strategies to limit that infringement going forward, monitor for any infringement by both your company or others. If anything comes up on your radar, assess whether there is an infringement claim and what the damage is. And again, remember early intervention really is key. So whether you suspect someone is infringing your IP or you receive a claim of infringement, seek legal advice promptly. We're here to help so that you can assess your options and develop really the best strategic response for you and your business. Okay. So that really concludes the content part of this webinar. You might find our publication useful and download our guide to protecting your brand in the resources tab or by scanning this QR code. You might also be interested in our upcoming event, Cybersecurity for In-House Counsel, Understanding Risks and Legal Obligations. You can register at the link below. It's on the 14th of November. So we're going to answer your questions shortly. While you submit them, I'll take a minute to tell you about LegalVision's membership. So by becoming a LegalVision member, your business gets unlimited access to our full team of 100+ specialist lawyers for all your business as usual legal needs. It's like having your own in-house counsel for a fraction of the cost. Our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registration, and much more, with options to purchase extra credit towards complex matters and ongoing disputes, which are charged on an hourly rates basis. So as a LegalVision member, you won't worry about the cost of lawyers ever again. Think of it as having your own in-house counsel. We'll take care of all your business as usual legal work so you can focus on running your business. We offer a dedicated service for in-house teams and general counsel to manage your high volume business as usual legal tasks. Our lawyers invest upfront in understanding what's important to your business and work as an extension of your in-house legal function. So to learn more about membership or desk extension and how that can help you, request a free consultation when the survey appears at the end of this webinar. Okay, so now I'll answer some of your questions. Okay, so what happens if someone copies your trademark and how do you make it unique? So we need to assess a few crucial factors. So is your mark registered? If so, what are the goods or services it's registered for? Is the potentially infringing mark substantially identical or deceptively similar to your mark? The infringer using that mark for the same goods or services for which your mark is registered? If all of that is a yes, then we'd probably suggest sending a cease and desist letter as a starting point, as I mentioned. And depending on the extent of the damage, I'd also then suggest perhaps discussing litigation. You can also think about some of the other less formal steps that I'd mentioned previously, like takedown requests or domain name disputes, if the other mark is trying to get registered, an opposition, or so on. In terms of making your trademark unique, it's important to understand that, I guess, the most highly protected trademarks are often the most abstract words that are not at all descriptive of your goods or services. So if you obtain a word mark as opposed to a logo or a composite mark, this is going to provide you with really the most comprehensive protection. You'll have a monopoly over that word, regardless of how the other side uses it, if they use a different logo or stylization. So when you're choosing a mark, you may well want to choose a really distinctive mark that's, a coined word or arbitrary term unrelated to your goods or services. I have seen similar brand names like ours. We are registered with IP Australia. What action can we take to protect our brand and product in Australia and overseas? Well, again, this really does depend on the situation. So it's great that you're registered. That's excellent. It would depend on what classes of goods or services your registration covers, how similar the names are or the marks are. Are they substantially identical or deceptively similar again? And are they operating the same area of goods or services? So again, you could keep monitoring the market. You could, if there is some kind of infringement, again, take steps like a cease and desist letter. If you're trading in overseas as well, you should probably consider trademark protection overseas, registration overseas. And then really ongoing management is helpful. So set up alerts for similar trademark applications with IP Australia or regularly review. Okay. New, cheaper copy products made offshore entering the AU construction market that look similar and are branded similar to our patented products. When and how to assess what is a patent or trademark infringement and recommend steps to consider to protect your past decade of hard work. Clients and engineers are now even getting our products confused due to this. Okay, so this depends on whether you, when we're talking about patents, whether you have a registered patent, that's something that we would need to look at, and whether there's a potentially infringing product where all the elements of your registered patent are being reproduced. For trademark infringement, again, is the brand substantially identical or similar to yours? It sounds like in this situation, there's a genuine confusion taking place in the market. This might be a breach of the Australian consumer law where you can't misrepresent to consumers that there's some kind of association between your brand or the brand of another or the products of yours and another. And that sounds like this could very well be the situation. I'd suggest collecting samples of the copy products and their packaging, documenting instances of confusion in the market, and then taking it to a lawyer to assess whether there's strength in that case, at which case, again, I'd send a cease and desist letter. Custom seizure, as I discussed, might be a really good idea in this circumstance, and potentially any court proceedings. I'd also talk to your manufacturer and make sure that they aren't manufacturing these products. That can happen a lot. And if you do know who that manufacturer is and they're international or you're trading internationally, you may want to look at international protection as well. We are a specialist food and brand designer. I understand we own all IP until we assign it to our clients, but what is the situation when an invoice hasn't been paid and the food client uses our work and it appears on shelves of a major retailer? Wow. Okay, so usually as the creator, you typically own the IP rights to your designs until you formally assign them to your clients. This ownership usually remains with you until payment is received, but that will really depend on the contractual considerations of your agreement. So review your agreement. Does it specify when IP rights transfer? Is there a clause about retention of those rights until payment? If there isn't, it might be something to include in the future. Use without payment might constitute an infringement in this case, in which case, if the product is now on shelves, you might have suffered damage. They might be obtaining profits as a result of the infringement, which you might be able to claim. Again, in those circumstances, I'd send a letter to the client, to the other side, reminding them of the outstanding invoice, asserting your IP rights, letting them know that they are technically infringing your rights at this point, and make sure you get payment. And if not, then that might be a case for legal action. As I said, future prevention might be, making sure your contracts are really, really clear on who owns IP and when it's transferred. Okay, so what are the ways you could lease, allow for a few or another entity who has infringed on your trademark with a business name in the same class? Would you fight them or negotiate? Well, you could do both. Negotiation options are useful. It depends on really what you want out of this, I suppose. So you could enter into a trademark license agreement. You could allow the infringing entity to use your trademark under specific conditions, charge a fee or royalty fee for the use, and set clear terms on how that mark can be used or maintain your brand. So something like a franchisor does. You could enter into a coexistence agreement where both parties agree on how their respective marks are used to minimize confusion. And you could also, it depends really on what you want out of this. You could negotiate a rebranding agreement where you give them a gradual phase out of the infringing name and potentially offer compensation to assist with rebranding costs. You could also acquire the trademark, purchase it from them, or sell yours. Again, cease and desist letters might be helpful. If the infringing mark they've applied to register it, you could oppose the mark. You might want to, if you want to take it really far, you could consider federal court proceedings. Negotiation in general is a really good way of approaching matters. You should always enter into a situation where you're willing to negotiate. It's going to be much more effective than just really, going gung-ho. I think that it's great to always have that ahead of you. Okay. Some other questions. So can I take legal action against someone using my unregistered trademark? So again, yes. If you have substantial rights in an unregistered mark, you could, and somebody else starts using that mark, you could make a complaint of a breach of the Australian consumer law, where again, you can't misrepresent in trade or commerce that you're associated or affiliated with another business in a situation where it causes consumers a potential confusion. So if consumers are being confused between your mark and another, then that could lead to a claim of misleading and deceptive conduct under the Australian consumer law. Can I use images I find on Google for my website or marketing materials? No, not unless you have permission or a license. If you want to use free images, you should try and find stock images that allow commercial free use. There are options for that, but just always be really aware of the license that is attached to an image. As even in some circumstances, it might allow free use, but not for commercial situations. So just always be aware of what you're using. What's the difference between mediation and going to court? Again, mediation is voluntary, it's confidential, it's where a neutral third party helps to find a mutually acceptable solution, I should say. It's generally faster, cheaper, and you know, more beneficial to parties in that they have some control over it. If you're not happy with any proposed solutions, you don't have to agree to them. There's no binding decision made. Okay, so I think that that's enough for questions. So let's wrap up. That's all really we have time for. If you have any other questions, please submit your details in the survey at the end for assistance with any questions we didn't answer, to learn more about membership. While this is a free webinar, we really do value, especially me, your feedback. So please complete the 30-second survey at the end and get in touch, as I'd love to help you with any of your IP infringement matters going forward. All right, thanks for joining us.